Part 2, Motion Hour, Louisville Family Court. An agreed order was signed by this judge electronically August 8th. We're in Motion Hour more than 2 months later. Judge just says that the order was entered erroneously. Here's the order, signed by the judge. They agreed. Mom said, I don't want any visitation. She's not paying any child support. He's had this baby since a couple days after birth. He filed prior to the birth because he heard that mom was going to give the baby up for adoption. Let's watch.
Erroneously in error. And so.
And I attached the email
right.
from your
but
assistant.
I'm the judge. She's not the judge.
I understand.
So,
I understand, but I don't think even under 6001 you can vacate an agreement of the parties.
Yeah, I can, because the judge that was filling in, the special status judge, felt like a hearing was needed. So that determination had already been made that a hearing was needed. And so it was signed erroneously.
Then I'm also asking that all those findings that were made be vacated too, because that hearing was remanded by your staff, Your Honor.
Has the child been returned?
My client is out there. Returned to who? He had sole custody.
And
there's nobody to return the child to.
So the parties have joint custody under law, just as long as he's on the birth certificate. Is he on the birth certificate? So you all have joint custody right now. Have you seen the baby? Is the baby not?
She's not made a motion to see the baby, Judge. She's not made a motion at all.
There's no custody orders in place.
She's not made a motion of any type. There is a custody order in place. I filed a valid 5905, which keeps those orders in place until you rule on that, Judge.
Well, it's going to be denied today.
I understand. Well, there's no motion she's filed. I'd ask that she file a motion that we have an opportunity to be heard on that motion if she's going to file one.
Well, the court's order is that the child be returned to Kentucky and that he not remove the child from the state.
And my client is, just so you're aware, he is out in the holding area with the child, so he is here in Kentucky,
right.
And he understands that.
Doesn't he go ahead and bring the child in here? Let's let mom take the child.
Judge, I'm going to object to that. Judge, you don't know the facts of this. You don't know the facts of this. She voluntarily had her dad come up here and testify about the fact that she came to my office and said, I don't want to see this child anymore. I just want to make sure.
Are you stable now? I know you said you weren't working and you needed a place to live and.
I do the kindergarten in 2 different hotels. I know that and he came back. We haven't had this situation. We have spoken with it. Right. We had both agreed that until we can get a place of our own, that his mother would take custody of her.
Okay.
And his mother has agreed to that.
And Judge, I object to all of that.
Okay, so it sounds like mediation might be
I'm fine with mediation, but in the meantime, the child should stay with my
client. We're going to let mom
client.
have the child right now? Okay, thank you.
Can I get an order that if you're denying my motion, I don't feel the order denying that, please?
Sure.
Thank you. And I object to her taking the child. She's not seen the child for 4 months.
This is an email from Judge Ogden's staff to the attorney for dad. Now, that was Motion Hour October 14th. When they signed this agreed order back in August, there was a special judge standing in for Lauren Ogden. I guess she didn't sign the agreed order. This is very important. The staff for Judge Ogden says, hey, Brian, that's counsel for dad. The above case was scheduled for a hearing next Monday at 9. I think Judge McDonald had concerns about the proposed custody order, but Judge Ogden later reviewed it and signed it. Are there any issues outstanding that you need that Monday hearing, or can we just remand it, which means take it off the calendar? Counsel for dad responded, I just spoke with my client and he and I agree the agreed order has been followed since being entered by the court. There is no reason for a hearing at this time. Remand it, please. The staff responds, thank you for the quick response. We'll go ahead and take it off the calendar. They